I'll go ahead and I'll get these posted when I get back. Um, but anyway, I'm going to try to cover chapters 17, 18, 19, and we'll see how far we can get there. It's pretty good stuff. 17, 18, and 19 doesn't sound like much. Public Law 280, which we got to talk about. You always got to talk about Public Law 280. Criminal jurisdiction which is really pretty thick, and civil jurisdiction, which it's really difficult to make a huge distinction between criminal jurisdiction and civil jurisdiction. It's sort of like criminal jurisdiction kind of controls civil jurisdiction, at least in Indian country. Quite a number of cases, and I'll point out those. I'll point out any cases that you don't really need to be familiar with. And I mean, there's a lot of extra stuff kind of in this, but I'm going to try to give you the, sort of the important or the significant and sort of critical part of these cases. Some of the cases are very obtuse, and I'm assuming that nobody has read chapter 17, 18, or 19 at this point, because I didn't assign it. So, but if you've gotten to get through it, that's fantastic. So we left off with 16 with the exam. So, you probably haven't opened it yet, but exam goes through 10 through 16. So far, after chapter 16, we have covered Indian gaming, which is chapter 24, and we covered natural resources, basically water resources, which is chapter 26. And I have, just in case we have time, chapter 25, which is cultural resources, and another one, but I don't know if we'll have that much time. We might. Without PowerPoint, I might go really fast. Okay. So y'all have any questions before we get started? Okie dokie. Well, if you have a question, just hit your mute button and ask away. Public Law 280. You probably remember talking a little bit about Public Law 280. We covered it when we were looking at the termination era. Public Law 280 came along in 1953, and it was most definitely part of the termination era. Now, Public Law 280 didn't terminate anything, of course, but what it did was it created an enormous amount of overlap and difficulty with understanding jurisdiction, and it's mostly associated with criminal jurisdiction, but it sometimes goes into civil jurisdiction. Most of the time it's criminal. All right, well, Public Law 280 was passed without the consent of any Indian tribes, was passed without the consent of the states that it would really affect. It was your textbook author, says, well, this is it was part of the politics of the time. It was, during the early days of the Cold War, and Soviet Union was, calling out the United States and all of its, issues with ethnic minorities and so forth. I don't know if that's exactly the case, but, it's probably partly the case. It was also, and again, I like to call the Indian Claims Commission part of the termination era. And it was, it came out during Truman's administration in 1946. So the Indian Claims Commission tried to, was a vehicle for the federal government to sort of wash its hands of its nasty dealings and underhanded dealings with treaties and tribes and such. I kind of consider that to be more termination than the Indian Reorganization Act. Most definitely, Public Law 280 was part of the termination era, and Public Law 280 was passed in 1953 at the height of McCarthyism and the Cold War. but I tend to think it was more pragmatic and more associated with the times that, the idea of sovereign Indian nations existing after World War II was an idea that, a lot of Americans thought was outdated. We can't help that. Um, but it was also during early days of Eisenhower's administration, and I believe Eisenhower enjoyed a all around majority in Congress. I'm not sure about that, but I would imagine that was the case. Um, but nevertheless, um, the you know the federal government was a local entity in many Indian reservations, pretty much for the sole purpose of law enforcement, because of course states don't have jurisdiction most of the time. And so what Public Law 280 did was it realized that there were some issues. There were some places where uh, number one, there was usually a really small population of, really small Indian population on a very isolated reservation. Um, and rather than installing, a federal presence at that place, it seemed to make sense to the authors of Public Law 280 that, well, why don't just allow the county sheriff's office to handle the burglary that's going to happen every 5 years, rather than keeping federal officers available. So I think it was largely a money saving thing. And your author does say that it was very much a politicized law. It looked good on paper in Washington, and it probably looked all right, to U.S. congressmen. But when it was enacted, when it was put into put into action, nobody liked it. Everybody who was affected by it, that is the states and the tribes, neither the states nor the tribes liked PL 280. Um, so why was it enacted? Well, it's kind of weird. It's hard to say, but we do know that it was pragmatic in the sense that it was an attempt to move mostly small Indian tribes and small reservations under the guise of state criminal jurisdiction. Okay, so the states received, and see, how was it? Maybe we can have a discussion here. How was it kind of a raw deal for the tribes? Well, of course, the tribes are losing their inherent sovereignty, um, and the states are, they're basically the states are going to overrun their authority, and that's just, you know, we know that Congress has that power, uh, but obviously the tribes were upset about it. How about the states? How did the states get a raw deal? At least there are two types of states. There were the mandatory states, which were like California, Nebraska, Wisconsin, Minnesota, um, Oregon, with the exceptions, blah blah blah. Okay, so and then Alaska later. So those, and I may have skipped one. I don't know. Why were those the why did number one, why did we have mandatory states, and then why were there optional states? All other states were optional, right? And not that many states opted into PL 280. When they did, they typically did it with a very limited scope. All right. So anybody want to answer that question about why was it a raw deal for the states?
They didn't have any input on it, and then they have to hire and be able to maintain and patrol those districts, and they never were asked for input on the matter or if they could afford it.
Absolutely. It was an unfunded mandate. So basically, the federal government strapped the states with more responsibility by extending their jurisdiction, but it didn't provide any money to do that. And surprisingly, the federal government didn't provide any funding to support that. They just handed it over to the states, and the states were, you know, reluctant. Number one, because they knew, trying to enforce law on an Indian reservation when Indian reservation or the Indian tribe didn't want you there anyway. Well, that's not real healthy, But anyway, thanks for your answer there, Heath. Um, so the idea here was that the states get jurisdiction over Indian tribes. The pragmatic side of that is, like in Oregon and Wisconsin, those tribes or was it Minnesota? Anyway, a couple of the states had, except I guess I'm looking at the law here. I can tell you, a couple of the states had certain reservations. Minnesota had, all of the state except the Red Lake Reservation, and Oregon, all of the state except Warm Springs Reservation. Why were those reservations, you suppose, exempted?
Because the difficulty it would have taken to take them over.
Well, I'm not really sure about that. From what I've been able to find out, it seems that there were some reservations, some tribes that had fairly well operating police forces and sort of proactive court systems. So I think those, I could be wrong, but I think those exceptions are typically non-problematic areas.
So they didn't need to be patrolled in the first place.
Yeah, they basically didn't need it. They were handling themselves all right. Let's see. All right. So anyway, we know kind of the not necessarily the purpose of PL 280, but here's how it played out. The states got the unfunded mandate. Any federal law enforcement was just removed. So state law enforcement generally didn't focus on it and tended to neglect the Indian reservation. So here we have an example of where the federal government has an intention of making things a little bit more efficient when in fact they wind up, in some cases, the Indian reservations wound up being less safe, less law enforcement. Well, let's see here. In 1968, when the Indian Civil Rights Act was passed, the PL 280 was amended so that two things could take place. Tribes, if states wanted to assume jurisdiction over reservations, they had to receive permission from the tribes. So new states that wanted to go into PL 280 and wanted to take over jurisdiction, which there weren't very many, had to get permission from tribes. Well, maybe the tribes didn't, want to bother with law enforcement. Maybe they didn't care if the state handled it. But in fact, there was zero examples of tribes allowing states to come in and take over. So that's the first part. The second part is also in that amendment in 1968. The amendment also allowed states to basically get out of the program, retrocede their jurisdiction to the federal government, and some immediately did that. So, we don't want in. We didn't want it. Nevada did that, for example. Nevada wasn't even in it that much, but Nevada decided to get out. Well, what did PL 280 do? What did PL 280 do? Well, it's still around, and number one, it was a law that was never entirely implemented, like so many facets of Indian policy. it was more than likely unsuccessful. I mean, I think we can safely say is unsuccessful. It was incredibly unpopular, and um, what did it do? It made understanding jurisdiction between states and tribes incredibly difficult. That's about it. No, most of the time, when something's passed, you got to, you know, a new law or a new court decision comes into play. If you're in a PL 280 state, you got to kind of work through the filter of how this is going to affect a PL 280 state. Nebraska is still a PL 280 state. Oklahoma never was, thank goodness. But like I said the other day, we kind of were a PL 280 state before PL 280. So at least we thought we were. Okay. Well, then there's this case, Bryan versus Itasca County. And your textbook author discusses a little bit about differences between civil law and criminal laws. Anybody need any explanation further than that? He refers to criminal law as public law. Basically, it's the state. The state comes after you for violating some ordinance or law or something. Private law or civil law, and usually involves two parties. So, the idea here is that one under one sovereign, you can have two different types of cases. You can have, in a criminal suit, in a criminal lawsuit, or in a criminal case. Sometimes criminal cases can be sort of supplemented with a civil case. All right. So, and sometimes a civil case leads to the discovery of a criminal case. Um, but in Bryan versus Itasca County, this was kind of a funny story. I thought. I mean, in fact, a lot of the ways that these cases arise is actually sometimes pretty comical. Um, and it becomes so theoretical. But anyway, remember how this one? Well, you haven't read this, but um, essentially, this guy owns a mobile home on the Minnesota Chippewa, or on a reservation in Minnesota, which is PL 280 state, right? So he's he's billed by the state or by the county for personal property tax. Okay, and he has a mobile home parked on Indian land. He is a Native American tribal member, and the state, because it's a PL 280 state, they think, well, okay, we're PL 280 state, then we have authority over Indian country now, so let's start taxing them. And how do you suppose that worked out? One of the big problems, I guess, one of your textbook author, makes a distinction between criminal law and civil law, because criminal law is a lot easier to sort of conceptualize when Indian country is involved. When you're looking at a civil case, like somebody suing somebody else, and there's assets involved, there's often a big problem because uh, tribal governments, reservations have certain immunities. Number one, taxation by states, but also things like real property cannot be you can't encumber it. You can't put a lien on somebody's home, or at least somebody's real estate, if they're in Indian country, right? So there's some nuances there. Well, in this case, A mobile home, by the way, is not considered real property. It's considered personal property because it's mobile. Um, and anyway, so this guy he gets a bill for what is it, $147.95. All right, and he says, "Well, I'm on Indian country. I'm not going to pay this. This is state tax. I'm not supposed to pay a state tax." So he challenges it. It is actually, and he challenges it in state court, and it winds up going to the Minnesota Supreme Court, which then says, "Yeah, we have the authority to tax you." All right. So, of course, he appeals to federal court, and it goes all the way to the Supreme Court. And so this is 426 United States 373, and it's from 1976. This is Bryan versus Itasca County, Minnesota. Now, this was, you might think this was kind of cut and dry, right? States can't tax Indian country; they can't tax personal property, but there was nothing about taxation or not being able to tax in PL 280. So that was a slippery mess. What the Supreme Court wound up doing, right off, the Supreme Court figured out this is not, this can't be. So, but they couldn't find language in the law that would, obviously nobody did. So the Supreme Court went into the congressional record to look at, the transcripts of committee meetings and that sort of thing, and they couldn't find anything where there was any intent for the states being able to tax personal property in Indian country. So what do you think they did? They used the Indian canons of construction, and they said, well, reservations, that even if they're two PL 280 states, in general, we don't expect states to tax. So it ruled in favor of Bryan, and the Supreme Court came back to the Minnesota Supreme Court and said this: if we had intended for the state to tax property in your state, we would have terminated the tribe, and then you can tax them. But if they're still a tribe, if they're still sovereign, you can't tax them. So, all right. So the Supreme Court says no, jurisdiction over reservations is, in terms of taxation, the state doesn't have that. Now, if Congress specifically allowed the state to tax Indian country, which it wouldn't, then that could be possible. All right. Well, any questions on that? Now, at this point in this chapter on PL 280, this is where California versus Cabazon Band of Mission Indians is provided. It's just a little, pretty small excerpt. I mentioned it, however, with Indian Gaming on Monday. And if you can recall that discussion, that's, we probably don't need to go into it too much. Just keep in mind that California was a PL 280 state, still is. And California obviously kind of enjoys its authority, its governmental authority. But it was a PL 280 state, right? So it believed, the state figured, well, okay, we can regulate. And the finding, of course, in that Supreme Court case was that the state did not have the authority to prohibit the Cabazon banned from doing high stakes bingo because, based on what California had already allowed, it not only had it not only had allowed card games and charitable sort of raffles and bingo for the Catholic Church, but it also had parimutuel horse racing and a state lottery, which it advertised all the time. So the Supreme Court says, well, California is promoting gambling, yet it tells this Indian tribe that they can't do it. Another facet of that story is that the federal government at the time in the 80s during the Reagan administration the BIA was telling tribes, do anything you can to figure out how to make money. Use your sovereignty to make money. They were encouraging what we would later call Class 2 bingo or Class 2 gaming. But once tribes started trying to move into casino gambling, that's when some states reacted, and California reacted. So, but it's just a wonder why California did that. I don't know. Clearly, they were okay. So, what the Supreme Court said was, if this were a state like Oklahoma at the time, if a tribe in Oklahoma in 1986 would have been doing games like roulette and blackjack house games, which were clearly illegal in Oklahoma at that time, then Oklahoma could have shut them down based on their authority, and only if Oklahoma was a PL 280 state, if they were doing so for criminal reasons. But since California allowed gambling, they were essentially regulating, and you can't do that. So you can't regulate the tribe. That would be the authority for. Anyway, so PL 280 has had many of the opposite effects that it was intended to fix, and basically law enforcement got weaker. The federal government was eventually called back to help, and that's what happens when the federal government fixes things that aren't broken necessarily. All right. Well, that's all I want to say on PL 280. And I'm ready to leave PL 280, if you all are. Okay. Let's move on to criminal jurisdiction. And this gets pretty interesting. Criminal jurisdiction, Chapter 18. Criminal jurisdiction was something that the federal government and the tribes had discussed from the very beginning. Earliest treaties involved how to deal with white people running rampant, or white people in Indian country and tribal members outside of Indian country. And you remember generally what the language said about that in the early days, let's say even before the Constitution. Well, generally the wording was that you keep your people over there and deal with them in your way, and if we have any of your people over on our side that get into trouble, we're going to send them back to you. And if any of our people get in trouble on your side, please send them back to us, and we'll deal with them. Okay. So it was an attempt to separate jurisdiction from the beginning, but that was the federal government versus the tribal governments, right? Not the state versus the tribes. Your textbook doesn't mention it, but really, if you want to look at criminal jurisdiction being formalized, you can look at the most of the treaties that were coming in the 1780s, 1790s, Treaty of Holston, that sort of thing. In 1817, however, there was a federal law passed called the General Crimes Act. It's not mentioned in your book. And so this was a federal law, 1817. Most people refer to it as the Indian Country Crimes Act. And what this did was it extended federal jurisdiction over Indians and non-Indians in Indian country. This is the beginning of, the contraction of tribal sovereignty over non-Indian people, 1817. So federal jurisdiction was extended to cover crimes by both Indians and non-Indians within Indian country, but not crimes by Indians in Indian country, which was left to tribal law and custom. Okay. So what it did was it said, we're going to cover this crimes that are committed by Indians or non-Indians. We're going to deal with these, but if it's Indians only in Indian country, that's your concern. And that, of course, was the rule, right, until 1885, until the Major Crimes Act was passed. And that's when the United States government, federal government, said, okay, well, we're going to extend our jurisdiction into crimes that occur only with Native American perpetrators and victims within Indian country. And if those are major crimes, the United States is going to take jurisdiction if it wants to. As we know, in Talton versus Mays, doesn't always decide to do that. But so Ex parte Crow Dog in 1883 brings about the Major Crimes Act. Okay, so the United States extends its authority into Indian country in all ways. And we talked about United States versus Kagama, which was basically the verification of the Major Crimes Act. It was kind of a test case of constitutionality of the Major Crimes Act. So that was, another sort of chip away at tribal sovereignty over crimes within Indian country. And what it did was, of course, it showed that Congress has plenary power over the tribes, and that would continue to get more and more authoritative until the Indian Reorganization Act. Okay, and you might even say that tribes still retain some authority over their people, even if they're not subject to PL 280. Anyway, let's move on here. Well, one of the most damning cases when it comes to tribal sovereignty is, and your author thinks without a doubt the worst or the most damaging ruling, was Oliphant versus Suquamish Indian Tribe in 1978. Okay, so this is the one that this particular chapter is really built on. And in fact, when we get into civil jurisdiction, Oliphant, remember that name, Oliphant keeps coming up. Oliphant will continue to haunt Indian sovereignty for a long time. Okay, now this is 1978. It takes place in Washington State. Interesting how Washington State's always often the scene of these things. But It was the issue was that um, in there was a festival going on, and there were native peoples in Indian country, um, non-native peoples at this festival. There was a drunk driving incident. Oliphant was the passenger in this car, and while the tribe had actually tried to get federal officers and local sheriff's department officers to help enforce um, security at this festival. The sheriff's office sent one deputy who left early, and the Bureau of Indian Affairs didn't send anybody. So the tribal police were trying to keep the peace at this large event, and what happens is this guy, this non-Indian guy on Indian country, gets into an altercation with one of the tribal police officers. Okay, and so they take him into custody, and then you've got this issue where the tribe is trying to enforce trying to enforce its own ordinances within its own territory against a non-Indian who was clearly, a perpetrator, a person who was challenging the authority of the tribe. Well, this particular, in this case, what happened was while the tribe was attempting to prosecute this guy, a non-Indian in Indian country, of course he appealed and went to the Supreme Court. The Supreme Court said, in so many words, and this was a William Rehnquist, Chief Justice William Rehnquist opinion. He wrote the majority or the concurring opinion for this case, and it was a long opinion, but basically he said that that there is no tribal government doesn't have any authority over the crimes committed by non-Indians within Indian country. Okay, so that's the Oliphant case. It basically was a Supreme Court case that ruled that tribal court does not have any authority to prosecute non-Indians even when they commit crimes within Indian country against Indians. All right. Now, abstractly, this is kind of like, think about it. It's kind of like barring states from having, non-PL 280 states. It's barring those states from coming into Indian country and enforcing state law. But it was a major hit for tribal sovereignty. The ability, so basically, it created a big hole. It created a in a sense, it created a refuge for non-Indian criminals. Because they knew they could do what they wanted to, and tribal courts wouldn't be able to do anything. Tribal police wouldn't be able to arrest them. So this prompted what was referred to as the Duro fix. The Duro fix was, and by the way, okay, we're dealing with this Murphy case, McGirt versus Oklahoma deal, which when I get to civil civil jurisdiction, and this will actually kind of answer some of that, but the part that Sarah is interested in, actually, I think. Um, but these big questions, when we run into a real obstacle, like I think what the governor ran into the other day, what's going to happen here typically is, well, okay, you can tell me. Whenever we're at a sort of a Supreme Court quagmire where there's a big problem that we don't know exactly how to fix, what happens? What tends to happen? Think of ex parte Crow Dog. How did what
So like the Major Crimes Act came from that.
exactly? Congress passes a law. So, if I were a betting guy, and I'm not, uh, this big mess that is eastern Oklahoma now might wind up getting we might wind up getting some federal legislation to fix this. We'll just see. Congress can always undo things, apparently, in Indian country. Well, anyway, the Duro fix. The Duro fix was one of those quick remedies, I guess we could call it, and this was passed as part of that amendment to the Indian Civil Rights Act in 1968. Well, excuse me, it worked off of that. In 1991, what did it do here? Let's see. The Duro fix. Okay, it was in response to that. What it did, it went into the Indian Civil Rights Act where there was a part for. I'm sorry. I'm thinking of something completely different. I'm wrong. That's not the Duro fix. This is why I need my PowerPoint. Sorry. Let's see here. Okay. Well, anyway, it created a hole in the law. So you have this ruling, Oliphant, that basically non-Indians can't be prosecuted in Indian country. What was it? Okay, well, I think Oliphant creates this issue, and one of the things that came up was, how do you deal with domestic violence, for example, domestic issues, when there are non-Indians and Indians involved in disputes, or if there's domestic violence between a man's the perpetrator, and what if the man in a domestic violence instance was a non-Indian? All right, so what do you do about that? And that, of course, that was a big problem, and it was dealt with by in 2013. In fact, it was dealt with by they call it a reissuing, or a reauthorization. There was a law passed in, what was it, 1994. 1994 law was called the Violence Against Women Act. And 1994. So what that after this in 2013, it was reauthorized so that tribal governments could, in fact, extend authority over male non-Indians involved in domestic violence. Okay, so that's like the only exception to Oliphant now, and it, thank goodness. But in PL 280 states, this isn't an issue, right? Well, no, it's not an issue. So anyway, we have this Oliphant kind of hole in tribal sovereignty. You can't arrest, and you can't prosecute. Tribal courts can't prosecute non-Indians within Indian country. Of course, the federal government can, but it's not something that the tribal police can deal with so easily. Maybe I do need PowerPoint. So the reauthorization is in your textbook, and okay, now I'm getting back. Okay. That left another issue that was something I've wondered about quite a long time, and that is, okay, you know how the federal government classifies people as Indians? No tribal affiliation; they're just Indians, right? You're either an Indian or you're not an Indian. When it comes to the tribal courts, okay, when it comes to the tribal courts, can the tribes, we know that the tribes can't prosecute non-Indians, okay? But what about non-tribal members? And this was an issue that came about with Duro versus Raina in 1990. Okay, so Duro versus Raina was a case in which there were two Native Americans involved in an incident within Indian country, and the tribal court attempted to prosecute this this accused guy who was a member of a different tribe. Okay, and so he appealed. He said, "No, this tribal court can't try me because I'm not a member of your tribe. I'm with a different nation. So what's the difference between me and the non-Indian there?" Okay, so that's actually a part that you can, if you think about this, it actually gets kind of interesting, right? If the federal government or if Congress allowed, or the Supreme Court allowed any tribal court to prosecute any Indian, regardless of tribe, what does that say about tribal sovereignty?
It kind of brushes that under the rug.
In what way?
Just because they're from a different tribe doesn't mean that tribe doesn't have their own sovereignty.
Okay. Well, what happened was Duro versus Raina. The guy appealed, and it was found that he's not eligible. So what happened was that's when Congress passed this Duro fix thing. It was an attempted to fix the problem created by whether or not a tribal court can prosecute somebody from a different tribe. So the Duro fix was all it did was it changed a few words in the amendment to the Indian Civil Rights Act, And that was, I guess that was 1991, the amendment to the Indian Civil Rights Act. And basically it said criminal jurisdiction over all Indians. So basically Congress did the quick fix, but when they did that, they really violated sovereignty, because rather than treating each nation as an individual, it's making a class. It's calling Indians a certain class. And if Indians are a certain class of people, then really where, in the case of the federal government, if they're just a certain class of people, then where does sovereignty originate? Sovereignty would be originating with the federal government, and they're really not sovereign. Remember that case last Monday? So if the and so that was a big problem. The Duro fix placed all Indians in one category. So if you were Cherokee and you're in, Window Rock, Arizona, and you got arrested by the Navajo police, then they could treat you like a Navajo. But if you were not a member of the Cherokee Nation, they couldn't do anything to you. Okay, so then we've got issues like, the 14th Amendment, equal protection, that sort of thing. So the Duro Fix. The Duro Fix was an amendment to the Indian Civil Rights Act of 1968. It was a 1991 amendment, and it simply did a blanket statement of all Indians would be prosecuted by tribal courts. And that's just not logical. It doesn't respect tribal sovereignty, in my view. The challenge then came actually the challenge was not very quick in coming, but eventually the challenge came along called United States versus Lara, all right, Lara, U.S. versus Lara. That was the challenge. That was a case that basically tested, whether or not that Duro fix could even be done. And this is a very complicated case, U.S. versus Lara, and the excerpt in your textbook doesn't tell you a lot. If you go look at this particular case, Justia or something, you'll find that it's incredibly abstract, because it's not really about whether or not tribes can do this. It's about whether or not Congress can fix it. Okay, so the case was about a non-member Indian being prosecuted by a tribal court. The question then in this the Supreme Court question was, does Congress have the constitutional authority to relax, and that's the key word, relax restrictions that other branches of the federal government, the judiciary in particular, have placed on tribal legal authority. Okay, and so this was a really convoluted reasoning, but Stephen Breyer is the one who wrote this opinion, and he provided he numbered them 6 basic justifications for why Congress, and the ruling was that yes, Congress has the authority or the constitutional authority to relax restrictions. Basically, in other words, what I'm saying is Congress has the authority to change the rules. Okay, and if it gets into an issue, then it can change the rules so that things can work. That's basically what this is saying. And even though he was in the concurrence, Justice Clarence Thomas brought up a really, really important point that has no clear answer. he basically called this whole thing out, and he said, look, Congress can't possibly have plenary power over an entity that is actually sovereign. Okay, so there's this contradiction, and obviously this is a contradiction that goes right down to the root of federal Indian law. How can Congress call tribes sovereign when it changes the rules all the time, and basically they're only sovereign at the whim of Congress, or at least as long as Congress wants them to be. So anyway, Clarence Thomas brought that up. He says there's a serious contradiction here, and until that's worked out, federal Indian law is just going to get weirder and weirder and weirder. All right, and he didn't say that, but I'm not as articulate as Clarence Thomas, obviously. So criminal law, and I've got a lot more notes, but your textbook really doesn't cover a lot of the other cases. It doesn't cover the United States versus McBratney or Draper versus United States. These are in Williams versus Lee. These are important. But I think your text covers it in taxation and other areas. So at that point, I'll shift away from criminal jurisdiction, unless you'll have points you want to make or questions you want to ask. None? Okay. Civil jurisdiction. All right. Now, civil jurisdiction is basically regulatory law, right? And well, it could be regulatory or it could be tort between two people, one declaring damages or something like that. The most important facet, or a couple of cases here that be sure and read these cases, okay, and closely. Montana versus the United States established something called the Montana test or the Montana rule. And I really like this case because it got started by a fisherman. It's all about fishing. So it's about regulations, all right, but it goes into some seriously deep consideration because it brings up Oliphant. It brings up United States versus Wheeler. Remember United States versus Wheeler regarding the Navajo Nation? Remember that one? Somebody tell me, summarize the issue there and what the ruling was. United States versus Wheeler. I'll give you a minute. Eerie silence. You'll find United States versus Wheeler And
That dual sovereignty.
okay, the idea of overlapping or dual sovereignty. What happened in Wheeler, page 245? That's in the Constitution chapter.
I don't know. I missed it on the quiz too.
Oh, okay. United States versus Wheeler, 1978. Does the Constitution bar a federal case if it was already convicted in tribal court? So it's, remember the double jeopardy deal? And so in this case, this guy is saying, look, the Navajo Nation prosecuted me already. I did my time, paid my $30 or something or whatever like that was. And he spent 15 days in jail. And then the federal government indicted him on a more serious charge involving the very same incident. So the question was, is it double jeopardy? And this court case wound up asking the question, where does Navajo tribal sovereignty come from? Is it inherent? Is it part of, the Navajo sovereignty since time memorial, their ability to govern their own people, or is it because of the federal government? Are they really just a little tentacle of the federal government pretending to be sovereign? So that was kind of the issue there with Wheeler. So Montana, the Montana case brings up questions like, well, where does sovereignty ultimately originate? What is inherent sovereignty? All right. And in the case of Oliphant, we know that non-native people are outside the jurisdiction of tribal courts for whatever reason. According to Stephen Breyer, there's 6. So basically, the state and the federal government are going to be covering non-Indians. States can't cover Indians, and when it comes to crimes within Indian country. All right, so Montana versus United States is a very important one, and then Nevada versus Hicks is another very important case. And as also Plains Commerce Bank versus Long, another one, and that one's a local. That's one that happened close by here. I think. I'm not thinking of the right one. All right, so know those first 3 cases in this fairly long chapter. Let's talk about Montana versus United States. Anyway, it involved this Crow tribe. All right, the Crow tribe was a signatory to the 1868 Second Treaty of Fort Laramie. So they wound up with this reservation, and the issue involved the tribal council basically created hunting and fishing regulations. All right, and the problem came up when a non-Indian flagrantly violated the tribal ordinance. All right, and the question became, all right, well, there are actually 2 questions in this case. One was where was he? He was in the stream, okay? And the tribal game warden arrested the guy, all right? So you got a non-Indian gets arrested by a tribal official, and first of all, there were some questions about if he was in the river itself, the riverbed, who owned the riverbed? And so it was a question as to whether or not the tribe owned the riverbed, or the state owned the riverbed, or the federal government owned the riverbed. And that took a while to try to figure out. It kind of threw the whole argument for years. Eventually, when it went to the Supreme Court, the United States Supreme Court found that the riverbed itself was actually Montana's property, the state's property. But the you can read it later, but what this is a 1981 case, Montana versus United States, and it involved the authority of tribal ordinances to regulate, it's not criminal law, but to regulate non-member activities, non-tribal member and non-Indian activities. And this is where our Oklahoma case comes in, okay? And the Montana rule is going to probably clear up a lot of stuff for Oklahoma. Basically, it limits tribal authority to regulate non-member activities on non-member owned fee lands within the reservation, with 2 exceptions. In other words, a tribe can't pass a regulatory law, an ordinance like, a fishing license law. It cannot regulate activities of non-members on fee lands within a reservation. But there are 2 exceptions to that rule. And this is where it could get really interesting in Oklahoma. The 2 exceptions are non-members, non-tribal members, in consensual relationships with the tribe or tribal members. And that's a weird one. A consensual relationship, that could be like a marriage, I suppose. And number 2, non-members engaging in activities that threaten or have some direct effect on the political integrity, the economic security, or the health or welfare of a tribe. That second one is essentially handing the tribes a little bit more autonomy. Anyway, this specific case involved the Crow Nation's ability to regulate hunting and fishing on tribal lands by a non-tribal member. Specifically, the dispute was over access to fishing on the Bighorn River within the reservation, and the Supreme Court found that the Crows' attempt to regulate was inconsistent with the tribe's domestic dependent status. John Marshall, the ghost of John Marshall comes back to us. So you understand what I'm saying here? If a non-tribal member is on tribal land or on trust land within a reservation, that's different. The tribe has authority to regulate. But if, like the tens of thousands of people in the Creek Nation who are non-tribal members who own private fee land, they own it within a reservation now. The state, or excuse me, the tribal government cannot regulate their activity on private land. It can only regulate non-member activity on Indian land, on trust land or tribal land, or restricted allotted land. And that's just regulation. So here's a big question for me, or to me at least. If the Creek Nation, which is now a reservation, cannot regulate non-member activity of whatever the regulatory statute is, maybe it's, I don't know, let's make something up. Anybody want to make something up? What's something, like a regulatory thing that it's not a criminal activity? Let's say smoking. Let's just make something. Say that the Creek Nation passes an ordinance that you cannot smoke a cigarette in the open air between the hours of 3 and 5 p.m.
On Sunday.
On Sunday. Oh, there you go. that will only apply to tribal members, right, on tribal land. It will not, okay. So anyway, that allows all the non-Indians, to do whatever they want to on their land. But the question to me is, what if the state wants to pass the same regulation? The state can't necessarily target non-Indians. You know what I'm saying? So and the state can't regulate anything within the Indian reservation anyway. Not supposed to, unless it's a PL 280 state. And so what would the solution there be? I think there is one. Well, it's probably in both the tribe's interest and the state's interest to have some sort of regulation that works for all the people within the area. So what they're going to have to do, more than likely, is create some kind of compact structure, some kind of coming together of both the state and the tribe in order to make sure that there is jurisdiction for people, so that there aren't these loopholes, these holes in the law for certain parties, certain persons of whatever classification. Okay. So we're clear on what the Montana test is. Is there an exception, or the Montana test is tribes can enforce regulatory things if it is threatening their political integrity. All right. They can enforce on non-members if this activity that they're trying to regulate is affecting like their voting or something like that. But the non-members and consensual relations with tribal members, I have no idea where that would go. That's just, I don't really understand how that works. Okay. Now, Nevada versus Hicks is a little bit different. It involves it's actually kind of a interesting story. Involves a poacher, and so the state of Nevada is looking for this guy who they have information that he's been shooting endangered or non-game wildlife, bighorn sheep subspecies or something. And so this guy is the fish and game people from Nevada come search his house and they don't find anything. They're searching on Indian land, and they leave, and then they come back another time, and they thrash around in his house and damage some things. And so this guy actually wants to, or actually the tribe wants to enforce its laws against a state officer, state official. So here you got kind of a real issue. There was it's whether or not the tribe can, when tribal courts, when a tribal member sues a state official, can that be heard by a tribal court? What do you think? Well, the way things were going, you probably have a good idea. It's a fairly complex case, and I think it deserves more than just the one little page here. But basically, the the ruling is on page 403. Indian tribes' regulatory authority over non-members is governed by the principles set forth in Montana versus United States. So Montana, remember, is like the Oliphant of civil jurisdiction. So Montana, basically the ruling was, where non-members are concerned, the exercise of tribal power beyond what is necessary to protect tribal self-government or to control internal relations is inconsistent with the dependent status of the tribes, and so cannot survive without express congressional delegation. So the tribes have been, their authority to prosecute has been shrunk, okay, by these couple of court cases. So criminal jurisdiction, Oliphant is a big it's a major case. Your textbook author says, you know, the most significant case restricting tribal sovereignty in modern times. And in terms of civil jurisdiction, the Montana versus United States and the Montana test basically outline where tribal courts can enforce their laws in terms of civil regulatory issues, like smoking in your front yard. Okay. All right. Are y'all okay if we just keep going, or do you want to take a break? No response means yes. Okay, we will. Let's talk about cultural resources. And I'll finish with this one. We have a OSU has a really big name in Indian law who is an alum of OSU. His name is Walter Echohawk. Anybody ever heard of Walter Echohawk? He's written quite a few books on Indian policy. Well, okay, the thing that your textbook covers, well, let's see. Your textbook mostly covers this. We're jumping over to chapter 25. Right after Indian gaming. Cultural resources. This is primarily about about NAGPRA, and a little bit of it is about arts and crafts and cultural appropriation. Okay, I'm just going to talk about NAGPRA. It's Native in 1986, the Native American Rights Fund started working on a project to get legislation that would repair a lot of PR and would repair a lot of bad feelings that people in Indian country had about anthropologists, especially. All right. And by 1990, they were able to get Congress to pass the Native American Grave Protection and Repatriation Act, NAGPRA. How many of you have heard of that? A few of you, okay. The Pawnee here in Oklahoma had a really big hand in the passage of this legislation, and Walter Echo Hawk's Pawnee, by the way. Now, what is the Native American Grave Protection and Repatriation Act all about? This will be a discussion if you want. Well, anyway, this law attempted to address some sort of universal issues when it comes to Indian country, and that is it deals with the sacred, okay, in a sense, sacred spaces, okay. Up until we could probably say World War II even, archaeologists and others who would locate Native American burial sites would often exhume the skeletons of people, and these were considered artifacts, all right, artifacts of Native peoples. Now, some of these artifacts weren't that old, like maybe less than 100 years old. And what happened was Native peoples, learned about the fact that, like when I was at University of Nebraska in the early 90s, doing my degree there, there was a museum not too far away from our building, the Geography department, and this building was the Nebraska Museum of Natural History. Okay, Nebraska Museum of Natural History. Now, Nebraska has a pretty well-known anthropology department, and a lot of Native American scholars there. But the museum on campus had thousands and thousands of skeletal remains of Native peoples from Nebraska. And in the same city, in Lincoln, just about a mile or two away, was also the Nebraska History Nebraska History Museum, like the Oklahoma Historical Society, and it also kept lots of artifacts. Okay, well, the whole idea that Native American people are a little bit different than everybody else, and that we can dig their bones up and put them on display, that became kind of an issue in the 80s and the 90s, and the other side of that is there really wasn't a lot being done with them. Most of these skeletal remains were just laying in drawers in the basement of museums, and were marked by the archaeologists who dug them up. Well, there were a number of perhaps scientific reasons why they were even taken in the first place and taken out of their location. All right, moved off of their obvious burial sites. Some of these burial sites were historical, but many of them were simply finds that people had along the Platte River and Nebraska and the Missouri River. So the question was, this was something that was impacting Indian country, and the Native American Rights Fund made a case for this. Basically, they said, look, this practice of storing our ancestors in museum drawers kind of violates the First Amendment, violates our freedom of religion. It violates tribal sovereignty in order to sort of regulate our people's graves. In some cases, there were treaty violations. But the one that actually tripped it all, the one that was probably the most important, was um, the Equal Protection Clause of, was it the 14th Amendment? So the Equal Protection Clause, basically Native American peoples were being treated as a separate class of people that didn't have the same dignity or the same rights to dignity as everyone else. So, Native American Grave Protection and Repatriation Act is passed. Museums, art dealers, anthropologists were in possession of these remains, and the tribes wanted to have those remains returned to wherever they had been taken from. Okay, and so, well, the tribes are actually still in the process of locating existing graves and also repatriating bones from various collections around the United States. The NAGPRA does a few things. It, first of all, prohibits the sale of any sort of human body part. And, you know, by the way, if you've ever been to like, I don't want to say anything negative about it, but if you've ever been to the Woolaroc Museum up in Osage County, anybody ever been to Woolaroc? They have shrunken heads in Woolaroc, like real shrunken heads from South America. These are, you know, and anyway, you know, there is sort of a universal human dignity that we should, you know, recognize. Anyway, the NAGPRA also allows for unmarked graves to be marked. It allows for a process of repatriation of human remains and sacred objects from collections across the United States, a lot of universities, including a lot of universities, and repatriating these items, human remains and objects, you know, archaeological finds, back to their locations. Now, in 2010, the estimate was there were about 120,000 Indian skeletal remains, 120,000 bodies that were locked up still in museums. Okay, that's what this attempts to do, is to repatriate them. Now, of course, what this did was it pitted the academics who are sort of, you know, wanting to keep these against the tribes. And so what the law does was it created a way for or created a requirement if an institution wanted to hang on to any of these remains, it had to provide a really, really good justification, and it had to be a scientific justification. And for the most part, you know, there's nothing to say that you can't record these things and then return them. All right. So today, you know, the standard is that you don't take remains of you know, human remains from burials at all. And now just about every tribal government has a cultural resources division or office that's basically set up to enforce NAGPRA things and also to search for unknown burial sites so that they can be protected. Essentially like historic preservation. What do you think about that?
Seems a little late for something like that to come into play.
What?
It seems like this could have come about sooner.
Yeah. How many of us like to go to museums and see art objects, though, and tools and these things that were actually excavated with burials, though. I've been over to like Okmulgee to Creek Council House Museum. I don't know what I was doing. I was hanging around Okmulgee one day, and there's really cool. It's the old Creek Capitol, or what's it called? Um, anyway, it's a museum now, and um, you go up there, and there are these big, tall cabinets with these thin drawers in them. Like 20 drawers on a side. And I just started pulling those things out, and there's like all these Mississippian objects in there, and no security. At least this was back when. But I'm just thinking, how do they? How can they just put this out here? These are objects that are thousands of years old, and they're just kind of not protected or anything. But those, I don't know what happens to objects that are held by tribes. If those are different. I think universities that hold human remains because they're Indian remains, that's different than non-Indian remains. I think that's deserves a little. And at the time, back in the '90s when this was in the news, I thought it was kind of ridiculous, to tell you the truth. I thought, well, these are people who didn't know these folks, so why is it that they're just pushing this? But it's a human rights issue, and I think now I've learned to understand it. But I wouldn't want my relatives to be, their bodies to be in some museum with people looking at them, and elementary kids on field trips looking at them. It's not what they're supposed to be done. Anyway, so the Native American Graves Protection and Repatriation Act. I didn't say much about it. But, okay, so look, we have covered chapters 17, 18, 19. Those are the heavier chapters: PL 280, criminal jurisdiction, civil jurisdiction, and a little on cultural resources. That's chapter 25. I'm not going to get into chapter 27 today. We'll try to save that for next time. A lot of sacred space stuff there. But if you have a chance to read before next Monday, be sure and read chapter 27 and chapter 28 or 29. Diversity in Indian country, 28. So if for next time, well, please read chapters for the final exam, chapters 17, 18, 19, 24, 25, 26, 27, 28. Is that okay? And so far we've covered all except 27 and 28. And wow, PowerPoint keeps me on. PowerPoint makes me slower, I guess. I don't know. This is about all I really wanted to cover. Do you have anything else that you would like to contribute tonight? Thanks for being here, and thanks for your comments. Well, I know you've got a lot to do, so I'm not going to waste your time. And exam, you've got what, a week from, you still got 5 days, I guess, to get the exam in next Monday at midnight. You've got the report that's due tonight, right? Midnight. Paper. Okay. So, all right. Heath, you have a question?
No, sir.
Okay. Jared, you have a question?